welcome back. And so as we start off our first conversation today, we'll be looking at civil liberties and the civic space, with specific focus on the hashtag End Bad Governance protesters. Recall just early last week, the arraignment of minors for participation in End Bad Governance protests drew quite a flurry of reactions, with, of course, the intervention of Mr. President in that matter, ordering that the charges be dropped against them and those children be reunited with their parents. And of course, in Kano as well, we saw some teenagers who were also arraigned for participating in the hashtag End Bad Governance protests. According to reports, these protesters were seen with Russian flags, and they were, conspiring, allegedly, to topple the democratically elected government. Now, a civil society organization, the Gavel, has petitioned the Attorney General of the Federation, urging him to invoke his powers to intervene and for charges to be dropped against the hashtag End Bad Governance protesters in Kano State. The Gavel is that organization, and an associate partner of that organization joins us now for this conversation. Good morning and welcome to the Morning Brief, Mrs. Funmi Adedoyin, associate partner of the Gavel. Thank you for joining us.
Thank you for having me. So it's very good.
Yes, it's good to have you as well. So as we start off, according to reports from about last week, we also saw human rights lawyer and senior advocate of Nigeria, Mr. Femi Falana, calling on the Attorney General of the Federation to initiate proceedings to have charges dropped against those protesters in Kano State as well. So what evidence are you providing to the effect that charges have not been dropped against those protesters in Kano State?
Thank you. It is very, it is very alarming that over 90 days after this protest, we are still at this point where we are talking about the right to personal liberty and freedom of movement and dignity of human person of these protesters. When we got report of this, the detention of these protesters in Kano, our legal team was at the correctional centers in Kano to meet one-on-one with these protesters, evaluate their cases. We went ahead to the court to get the first information report charged against them in the court. And we discovered that so many of them are still in detention because they have been remanded on holding charge by the police. And because the charge, the courts where they are being charged in don't have the jurisdiction to sit to decide their matters. That is why they are still languishing in the correctional centers up until today. Up until today, we have filed fundamental rights enforcement application on behalf of these protesters. And when we procured the charge sheets, which was levied against them, we discovered that many of them were charged with frivolous allegations such as disturbance of public peace, illegal gathering, and so many treason, conspiracy, and unlawful assembly. And it's very unfortunate that we are talking about these criminal charges for those that merely participated peacefully in a protest. And as an organization at Gabo, we have since filed a fundamental rights application on their behalf at the court, seeking for a declaration by the court that the continued detention of these protesters is a violation of their rights to personal liberty, and for a declaration by the courts to order the conditional or unconditional release of these protesters from the correctional center. So this is where we are right now. And also, we have also written to the Attorney General of Kano State for him to invoke and exercise his statutory power to issue a nolle prosequi, just like we did in Abuja for the case of the minors that were arraigned at the Federal High Court. Gavo wrote to the Attorney General of the Federation, and which led his intervention, also led to dropping the charges against the minors and the defendants in that case. And this is the same thing that we want, the same intervention that Gavel is seeking in Kano State for the chief law officer of Kano State, that is the Attorney General of Kano State, he also has the statutory power under Section 201 of the Constitution to discontinue these charges by filing an application in court for nolly to enter his power of nolly prosecute to discontinue these charges against these peaceful protesters. And if we true to the democratic principles on which our dear country is built on, and the rule of law to prevail, it is very necessary, and we urge the Attorney General to exercise the statutory power for the release of these peaceful protests. Participating in peaceful protests in Nigeria is not a criminal offense, and this should be seen. Thank you.
Thank you for providing that, that's setting out to help us understand what exactly is happening. The Attorney General of the Federation had been clear that the law enables the institution to try minors, but that the president only intervened in their case on compassionate grounds. Now, granted that the protesters arraigned in Abuja, the federal capital, were minors, but those arraigned in Kano State didn't appear to be particularly minors. They looked more like teens. Now, has your association weighed their own case on its merit and looked into the allegations leveled against them and been able to ascertain their innocence? Because some of the allegations cannot just be, waived. They said they were carrying Russian flags, and you said that they were charged with treason and all of that. So have you weighed their case on its merits to ascertain that indeed they were just protesting as citizens and expressing their fundamental human rights?
Yes, very correctly. We have ascertained the innocence of these detained protesters, and that is why we are providing legal support and intervention for just 13 of them. And when we evaluated their cases, we procured the first information report that was used to charge them and the proof of evidence that was used by the police to charge them at the magistrate court. We procured these documents, and when we evaluated these documents, we discovered that the police do not have any evidence to nip these protesters to the criminal charges, the false criminal charges that was actually they were arraigned for at the court. So they were just mere participants in this protest. They were just participants, and we were able to identify this from the documents, the statements they made at the police station, the first information.
Were these Kano protesters, some of those identified to be carrying Russian flags? And if they were, why were they carrying Russian flags?
From the 13 protesters, the 13 detainees that we are providing legal intervention for, none of them was carrying Russian flags or anything of that nature. And just like I shared with you, the charge sheets did not carry anything of this nature, because if they were, it would have been part of it. They were just charged with frivolous allegations like rioting, unlawful assembly, disturbance of public peace, and there were even no evidence in the proofs to point them to these offenses, and they were just merely participants in the protest.
So let's put it in context appropriately. You say you've seen the charge sheets. You didn't see anything like treason and all of those heavy charges that may amount to, if you're found guilty, you get a capital punishment. Is that what you're saying?
Yes, that is what I am saying. I am saying that from the evaluation of the charge sheet, what we found is disturbance of public peace, rioting, unlawful or illegal gathering and assembly, and the likes. And just to put light to this, in Nigeria, the police have this notorious practice when they arrest individuals, rather than to charge them to the appropriate court within the time stipulated by the law, they detain them for a while. After detaining them for a while, they take them to the nearest magistrate court to remand them, knowing fully well that these magistrate courts don't have jurisdiction to try these offenses. And because these magistrate courts don't have the jurisdiction to try these offenses, they remand them in the correctional facilities until legal advice is being proffered by the Director of Public Prosecution. Now, we understand how the criminal administration of criminal justice system in Nigeria work. It is quite slow. It is slow-paced. And before this legal advice comes out, these detainees, they have spent a lot of time, months, running into years in these correctional facilities before they are being charged at the appropriate court. And one of the steps that we are taking to rectify this particularly was that in 2018, my organization Gavo, we wrote to the to the Chief Justice of Nigeria to issue a practice direction mandating that magistrates, they conduct regular unscheduled visits to these police stations. Now, if these police stations visitations by the magistrates were being carried out periodically as directed in that practice direction by the Chief Justice of Nigeria, we wouldn't be here talking about issues like this. So these are some of the actions that we have taken regarding this matter.
So I'm curious to know why they are still in prison or being held by the police, because I know that with the Abuja case, the police had actually gotten an order to keep them for, I think, 60 days, and then they were now arraigned in court. So did you see any order to that effect? Because you're saying 90 days, but let's say August, September, October, this November, maybe about 90 days, maybe, perhaps you're correct. So did police get any order to keep them there? I just want us to get to some of the facts around the issue without speaking to some of the merits of the case since it's under adjudication. So did the police get an order to keep them for this long?
Yes, correctly. The police got order. You know, just like I mentioned earlier, they were remanded on holding charges by the magistrates.
Okay.
They have still had the correctional centers because they were remanded on the order of the magistrate. So the magistrate ordered that they be remanded until whether legal advice is out or until charge is filed at the High Court. The High Court is the one that has jurisdiction to sit over these charges. So that is what we have. And to answer your question about why they are still there, we discovered that so many of them have actually been granted bail by the courts. However, they are unable to meet up with the bail terms because the bail is quite stringent. So when we got the fact of their bail conditions, some of them were they were issued bail bonds worth 5 million naira, requested to provide house documentation, requested to provide attestation letters from their ward leaders. So many of them cannot provide this, and because of that, they are being detained continually at the correctional centers. So because many of them cannot afford these bail conditions, that is why we have filed the fundamental human rights enforcement and also sought the intervention of the Attorney General of Kano State.
Okay, so let's have an average age of these people involved, because with the issue of Lagos, sorry, not Lagos, now Abuja, we knew that, we saw the charge sheet, so we saw different ages. So what's the average age? But I know that names like Hajara Gambo, Nasiru Abdul Kader, Aliyu Idris, Usama Yahuza, Aliyu Salihu, Rabiu Lawan, Hasbullahi Rabiu, Mahe Ahmed, we're going to put up the names soon, Buhari Abdullahi, Ismail Musa, Aminu, Abubakar Danjumai, and Bashir Kabir. These are the names that we have from your petition to the Attorney General of the state. So what is their age range, for question number one? And then what are the responses you're getting from this petition?
Oh, thank you. From our evaluation of their cases, the age range is between 18 to 35. So many of them are youth, students, and we have not yet discovered a minor amongst them. So many of them are between 18 to 33. And up until now, we have not gotten a response from the Office of the Attorney General of Kano State. And this is why we are putting in the rights advocacy and pressure to move the Honorable Attorney General to exercise his statutory power. He has this power which has been granted to him by the Constitution to discontinue charges when issues of public policy, democratic principles, rule of law, and protection of the rights and liberties of the people are at stake. And this is one of the cases. So that is why we are urging the Attorney General of Kano State, as the Chief Law Officer, to intervene in this matter so that these protesters can gain their right to their personal liberties. It is enough that they have spent almost 90 days in detention and their right has been violated already. And this can be rectified with his intervention.
You say that the court got an order to detain them rightfully for 60 days, but because they're unable to meet their bail conditions, that's why they're still in detention. So they're rightfully being detained. I just want you to clarify that.
Okay, just like I explained earlier, that the notorious practice with the police in Nigeria is that when an individual is arrested, they charge them to nearest magistrate court in their jurisdiction. They charge them to this magistrate court, knowing fully well that the magistrate courts don't have jurisdiction to entertain these cases. The magistrate court cannot prosecute these cases, and because of that, the magistrates remand them at the correctional centers until the appropriate court that has jurisdiction is able to take over these cases, which can take months and even years. So that is the reason why so many of them are there, because of this notorious practice of the police in the first place of inordinate arrest, criminal detention of innocent citizens, and this is how they have found themselves in the correctional centers up until now.
So I see that there is an acknowledged copy that you have provided with us from the Office of the Attorney General, marked received. So it has been received, but you haven't gotten a response.
Yes, we are following up at the Office of the Attorney General for his response and his intervention.
Okay, so what would be your next line of action now, following this intervention that your organization has provided?
So our intervention that we are providing is not just one way. We are providing intervention also in procuring an order for the enforcement of their right to personal liberties from the High Court. I mentioned that we have filed an application at the High Court for the enforcement of their fundamental rights, and also an application for the court to order the conditional or unconditional release of these protesters. We have adduced evidence and exhibit in support of our application, which has been filed at the courts already.
So I'm just worried about a few things you raised, and I would like you to help us out, so since you're in the legal practice. So is it a question of not knowing the law, which I really doubt, or impunity, or oppression, or maybe there's an explanation we do not know? If the police knows that the magistrate court doesn't have jurisdiction, why then do they take them to those courts?
All of the above, I would say. This is where we have found ourselves, as Nigerians. This has come to be a very common practice with the police. Whether it's an issue of not understanding the correct legal processes, and that's why as an organization too, we are also pushing that police prosecutors should be lawyers, should be people who understand the law and legal processes. Many of these police officers don't even understand the jurisdiction of courts and which court actually has jurisdiction. I think it is just very easy for them, and it has become a matter of no mercy for them to just, file all forms of charges at the magistrate's court, knowing fully well that this would mean that the courts will not be able to sit over these matters, and the individuals will be detained at the correctional centers pending the time that the appropriate people to sit on these matters.
So without trying to take sides with the police, I'm imagining that I'm a judge and you bring a case to me and I don't have jurisdiction. You as a lawyer, what is the judge meant to do at that point? Because the judge is sitting, he didn't ask you to bring the case, you brought the case to the judge, but by law, the judge, I'm sure, understands that I don't have jurisdiction here. But somehow granted them to be remanded. Is that tenable in law, or what is going on from the end of the bench? Because we're just looking at all elements. Because of what you stated, the issue of human rights and protecting human rights at the end of the day, which our country is governed by the rule of law. And this issue of jurisdiction has been a thorn in the flesh in our judicial practice, because it's really funny sometimes when we see these things at the end of the day.
Yes, exactly. It's we are all just victims of, the entire pace of the administration of criminal justice, the ineffectiveness, and the challenges that, is facing the Nigerian judiciary. So for many of these magistrates, they are being stormed with a number of cases, a high number of cases on a daily basis in their courts. So when the police bring these cases, of course, they cannot order that the police should have continued detention of these individuals. So rather than to send them back to the police stations, they just order that they should be remanded at the correctional centers pending legal advice from the Ministry of Justice. In a democratic system or in a judicial system where everything works, this process is not supposed to take a very long time before they are attended to, or before the processes are being done. However, because of the high number of criminal complaints and cases that have been received by the court, the lower number of judicial officers that we have, as against the high number of cases that they have before them on a daily basis, and also the short staffing of the Ministry of Justice officials, all of these stakeholders eventually come to impact the pace of the justice process. And that is why so many of them, when they are remanded, they spend longer time than usual before they get advice from the Ministry of Justice.
Yeah, absolutely. We're just going to keep tab, and great work you're doing, but we will also try to use the opportunity. We would like to hear from the state government as well, the Attorney General or somebody from the state government, because they are the ones being called out here, so that they can have their own right of reply as soon as possible to know exactly what in terms of response it will be for these people that have been, held in custody for over, according to you, 90 days. Bukola.
Indeed, and the letter by the gavel also captures some of the responsibilities of the chief magistrate, which says that they have the oversight functions over police stations in their jurisdiction, to check issues of police brutality. I wonder if that has been effectively done. Maybe we'll be talking less about some of the things that we have highlighted on the program today. But we will keep our eyes on this story. We'll keep tabs with you as well. Thank you so much, Mrs. Funmi Adedoyin, Associate Partner with the Gavel. Thank you for your work and for coming through on the program today.
Thank you very much for having me.
And from here, we move on to the next leg of our conversation, which is that debate over the calls for the establishment of a National Coast Guard. Is it a tool of necessity or duplicity? Join us. We'll be right back after the standout.